Welcome to webinar 5 about some of the issues that are relevant to all legislation. As many of you know, there are a vast array of issues that affect all legislation. However, today the topics we will discuss are related to chapters 11, 12 and 13 of the Legislation Guidelines. My name's Guy Beatson. I'm the Deputy Chair of the Legislation Design Advisory Committee and a non-public service member. I'm also the General Manager of the Governance Leadership Centre at the New Zealand Institute of Directors. For today's webinar, there are 3 parts. We're going to start with a short presentation which explains a little bit about the Legislation Design and Advisory Committee. We're then going to move to a panel Q&A with our panellists who will introduce themselves shortly. And then we're going to open up to questions from you, the audience, to address any of the issues that have arisen or occur to you as we go forward. You can ask those questions using the Q&A button at the bottom of your screen. But first, a bit of an introduction to the Legislation Design and Advisory Committee. The Legislation Design and Advisory Committee is made up of members appointed by the Attorney-General to support good legislative design. There's a mixture of public service and non-public service members. And all the members are voluntary or unpaid for their LDAC work. In the case of the public sector employees, their time is loaned by their employer. The Parliamentary Council Office, or PCO, provides secretariat support, including advisors to support the committee, for which the committee is eternally grateful. Members have a broad range of backgrounds. We draw on members from legal and policy teams within departments, Crown entities, as well as academics, lawyers, barristers, and consultants. I should also add economists, of which I am one. A broad range of skills and experience is important because good legislative design is multidisciplinary. It's not just about the law. LDAC has 3 functions. We publish and maintain the legislation guidelines as supplementary material. That's the government's handbook for good legislative design, and we're looking at a few of the chapters of that today. The most recent edition was updated this year, but the guidelines have a decades-long history that are direct successors of the LAC guidelines. We carry out education and engagement activities like this session today, but also by department and by issue. And these activities extend our reach beyond our advisory function. It's common to see us make submissions to select committees that refer to the guidelines as well. And ministers are required to address consistency with the guidelines in cabinet papers for bills. Our advice function applies at 2 different stages. The bulk of our advice work is prior to introduction, when we advise departments that come to us and seek our advice. We also make submissions to select committees on rare occasions where there's a significant legislative design issue. We also aim to support good lawmaking. We're guided by the guidelines and supplementary material. The guidelines are not about policy, they're about the expression of policy in the law. This means you will not find us giving an opinion on policy. It's important to remember that the guidelines are just that, guidelines. These are not rules that must be followed. Our goal is to help ensure that conscious design choices are being made about the design of that legislation. Today, the focus of our webinar is on 3 chapters of the Legislation Guidelines, and that's about how new legislation relates to the existing law. So we're going to start with applying an act, chapter 11, which is about applying an act to the Crown. Then we're going to move on to chapter 12, which is about affecting existing rights, duties, and situations, and addressing past conduct. And we're going to finish the Q&A session, at least, on chapter 13, interpretation and application of legislation. So that's a bit of an introduction about LDAC, and I'd now like to turn to our 2 panellists today to introduce themselves. Perhaps we'll start with Sam, please.
Kia ora koutou. Ko Sam Miles aho. I'm a Principal Policy Advisor in the Department of Internal Affairs in the Local Government Branch and a member of LDAC. Kia ora.
Thanks, Sam. And Graham?
Kia ora koutou, ko Graham Morrison tōku ingoa. My name is Graham Morrison. I've been a member of LDAC since 2018, and as a day job, I'm a policy lead at Inland Revenue. Currently, I'm responsible for indirect taxes, but prior to that, I managed Inland Revenue's tax law drafting unit for a number of years. Really grateful for that experience because it gave me a great insight into the interface between policy drafting and legislative processes.
Thank you both, and it's great to have you both on board with us today to work through these issues. We're going to start with looking at the extent to which legislation should apply to the Crown. I'm going to turn to Sam first. What are the relevant factors to consider when deciding how new legislation is applied to the Crown?
Thanks, Guy. So the default position is that legislation doesn't bind the Crown unless it explicitly states that it does, and this is provided for in Section 22 of the Legislation Act. Having said that, usual practice is that legislation should apply to the Crown in the same way as it applies to everyone else. So at the legislative design policy development stages, we're required to consider whether there's any legitimate reason not to bind the Crown. So this is something it's a Cabinet Office requirement, and there's a Cab Office circular to support those considerations. And there's a number of factors that we need to take into account as to deciding whether or not the legislation should bind the Crown, to what extent, and whether it should partly bind or partly not bind.
That's great. And maybe I can turn to Graham, because you've both got really good experiences of this about whether this should bind the Crown or not. Graham, what do you think that kind of the tests are that should apply in terms of, and guiding our audience to some extent in terms of what that test is, whether something should bind the Crown or not?
Well, whilst there's no specific test or exhaustive list of considerations that apply in deciding whether an act should bind the Crown or not, you should ask yourself a number of questions to assist with your thinking. You're right. So some of the questions you might want to ask yourself include, for example, would binding the Crown create obligations over and above those on private people? Are there any unique circumstances that mean it would be inappropriate for the Crown to be bound? Are there any aspects of the legislation where liability could be seen as unjustified? And if so, what are the relevant circumstances where that could arise? You might want to ask, would applying the Act to the Crown impair the efficient functioning of government in any way? And are there financial costs of making the Crown subject to the Act justifiable? On that last point, you should probably look at a couple of things in particular to assist with that question. There are provisions set out in the Public Finance Act of 1989, and they're important here. And there's also really helpful associated Treasury guidance on this matter. Personally, I have found it useful in the past to reach out to your Treasury counterpart or vote analyst to get some help here. Moving on, if you like, to some examples of where a decision to not bind the Crown would be inappropriate. Some scenarios that wouldn't be appropriate would be where it's likely that the Crown will commit an offence, or it's merely convenient to not be bound. If it would result in an unfair benefit, for example, to the Crown, or if it adversely affected third parties. One other point to note is while it's quite normal, and you see in the Cabinet paper and guidelines, etc., that it's usually sufficient for an Act to say this Act binds the Crown or not. In some cases, it may be appropriate for only certain parts of the Act to bind the Crown and not others. There is an example in the Arms Act 1983, for example, that generally binds the Crown, but there are two specific exemptions within it. I mean, likewise, don't assume all similar acts are treated the same way. For example, in my particular area of work, the Income Tax Act does not bind the Crown, but the Goods and Services Tax Act, importantly, does, just as an example. I'll just conclude with a plug for Chapter 11 of the LDAC Guidelines, as you pointed out before, Guy. And also, there's really important, there's some links in there to further resources that you can tap into, and they'll help.
I guess there's one other piece to this, which occurs to me as we've been talking. I want to turn to Sam for this, because the difference between civil and criminal liability and the kind of the way in which that plays through with the Crown, how should our audience and other players in both the legal and policy communities actually think about whether this binding of the Crown or not should be civil or criminal, and how does that all work?
Yeah, that's right. That's another consideration in terms of binding the Crown, the extent to which either criminal or civil liabilities will apply, or whether there should be an immunity. And I think the starting point, particularly in terms of civil liability, is that any immunity needs to be specifically justified, and it shouldn't be overbroad. There is a provision for public servants to receive civil immunity through the Public Service Act. So that in itself doesn't justify immunity for the Crown. If civil immunity will apply, then it's important to consider what other accountability mechanisms there are in terms of holding the Crown to account for public acts, and also how any redress for wronged individuals would apply if there is civil immunity for the Crown. So there's a number of considerations again there, and similarly in respect of criminal liability. This is largely governed by the Crown Organisation Criminal Liability Act from, I think, 2002. That sets out a framework under which there's a broad definition of Crown organisation, and then a specific set of acts that its criminal liability can apply to the Crown organisations for. So that includes things like the Building Act and currently the Resource Management Act, soon to be replaced by the Natural and Built Environment Act. But this is the way in which the Crown can be held criminally liable, where that's seen as an appropriate accountability mechanism. So again, the question to consider for criminal liability is how the Crown should be held to account, whether criminal proceedings is the best way to achieve that.
I guess it's some really interesting questions that are about kind of incentives and so on and so forth. We don't have time to go into today, but certainly worth thinking about. So to bring all of that together, irrespective of the section 22 of the legislation, it looks like practically the best way for officials to begin their thinking is that the starting point of all legislation should be binding the Crown unless there are clear and justifiable reasons not to do so. And that gets even more complicated when you get into some of the criminal side of things that Sam's just covered off. For further guidance, there's helpful Cabinet Office Circular, which provides factors to consider when assessing whether it's appropriate to bind the Crown. We've referenced that in Chapter 11.2 of the Legislation Guidelines and linked in our online version of the guidelines. The Treasury guidance that Graham referenced before is also linked under Chapter 11 of the Guidelines. So that's really helpful, and that's even more accessible with the online version. It's worth saying, though, that this is not necessarily an either or. You can actually have hybrid options, which are worth considering, where there's only a justification for binding the Crown to specific parts of the Act, which is some of what Sam talked about as well. And if there's need to provide immunity from civil or criminal liability, that should be considered and justified separately too. So that's quite an involved process, much more involved than simply saying blanket, this should bind the Crown or it shouldn't. It actually requires a whole lot more consideration, and some of those considerations are outlined in the guidelines. I should say at this point that as we've already got one question, if questions occur to you as we're going along, we'll answer those at the end of the session as our third part of the session. But you can ask those questions now using the Q&A button at the bottom of the screen. So we're going to change gears slightly. I'm going to look at how the application of new laws should affect existing rights, duties, and situations, and how that law should address past conduct. So I think I'll turn to Graham and ask him, can legislation which is intended to affect future events have any consequences for existing situations?
Yeah, absolutely. Like it's essential that officials are aware of the many potential scenarios that can arise and explicitly account for those. I mean, if that's not done, you can easily see how that can lead to either uncertainty and at times unjust outcomes that ultimately have the potential to undermine the rule of law. So again, some of the considerations that you might want to be aware of here might include questions you might want to ask yourself. So what happens to rights that people hold that due to a law change may no longer be granted to anyone else? Another question, what happens to applications that have been filed but not considered by an authority at the time new criteria or rules come into force? You can see that rising, for example, in licensing cases or the like. Or alternatively, what happens to people who have, in many cases, paid large sums, for example, to obtain a license, only to have legislation abolish or amend a particular licensing regime? The provisions in law that deal with these types of issues are referred to as savings and transitional provisions. You may have heard of grandparenting provisions. This refers to both savings provisions and transitional provisions. An umbrella term. Terms used to cover both examples because it's not always a clear distinction between the two. I mean, in essence, the difference is saving provisions preserve a law, right, privilege, or duty that would otherwise be affected by the new law, and transitional provisions set out how the new legislation applies to things that have arisen in the past. Yeah, I mean, again, in my day job, I come across these types of situations occasionally in tax legislation, and you really have to look closely at the specific case that's in front of you. Often it's nuanced, and as such, there isn't necessarily any hard and fast rules you should apply. Key thing to remember, though, is that the main role of these types of provisions is to move from the old law to the new law in an orderly, fair, and efficient manner, and where possible, avoid retrospective effects. I'll just lastly say, look, these can be really complicated. They can be complex. Therefore, it's really important that you give yourself enough time to consider the potential implications on existing rights and duties. Consciously turn your mind to it. My advice is don't leave that sort of thing as an afterthought, because they can be complex and take up a lot of headspace for sure.
Yeah, it's certainly, and I think both Sam and Graham would agree with us, that it's one of those things that is often an issue in terms of our discussions with departments and our legislation design advisory committees, subcommittees on various bills and the precursors to that. But I wonder, Sam, just to finish off this piece, are there some particular questions you think that legal advisors and policy advisors should be thinking about when they come to these transition or grandparenting type provisions?
Yes, absolutely. One of the key things to consider, as Graham said, it's complex how you transfer into a new legislative regime, and one of the key things to consider is how you'll deal with processes that are currently underway when you do the transfer, how they'll come into the new legislative regime. And so in local government legislation, the way that local government works is really on a planning cycle. So when the legislation and the legislative requirements change in local government legislation, you have to consider how those plans will translate into new requirements. And that applies to all kinds of processes that will be in place under the old regime as moving into the new one. There's a question as to the timing for when the new law will start and the scope of its application, and there's some choices to make around this. You can have phased commencement of new legislation. Sometimes it's potentially the best solution is to have the old and new regimes running in parallel, although this should certainly be approached with caution and in considerable discussion with your PCO drafter, because if you have dual regimes running for a lengthy period of time, it does become, there's a risk of confusion there. And then there's also the need to consider whether there are any existing provisions that should be expressly saved, so whether any of the old provisions need to continue after commencement of the new legislation. So The Legislation Act has default provisions for transition and into a new legislative regime. This is sections 31 to 39. And it's important for us in designing legislation to be familiar with the default provisions and to understand how they will assist us and whether anything different is necessary in our particular circumstances. And so the typical approach is that the transitional and savings provisions are collected together in the first schedule to the Act so that practitioners know where to find them to support that clarity and reduce that risk of confusion. It is a complex and technical area, and as well as looking at the LDAC guidelines, of course, there's also a really helpful transitions and savings checklist on the PCO website, which asks a number of questions to get you thinking about the possible scenarios you need to cover.
Yeah, I mean, your observations have made me wonder, you know, so sometimes we say you've got to be deliberate and you've got to think about all of these things. I think the one thing in terms of what you've just talked about is the fact that there are some default provisions in the Legislation Act that actually help deal with this stuff, and also the legislation guidelines themselves, plus help from PCO is pretty important. Now, a lot of this conversation, though, and I'm going to turn to Graham for this, is around this retrospectivity question. And I think we've got a kind of a golden rule that says, you know, basically we shouldn't do things that are retrospective as far as is possible. But I guess the question, Graham, is when is a retrospective application of the law appropriate?
Yeah, I mean, as you say, Guy, it is generally accepted that law should ideally apply prospectively and support the law. However, as with many things that we look at, this presumption against retrospective application does exist on a spectrum. Again, you often have to look at what's in front of you in any given issue, and again, not black and white. There are some times when that presumption is stronger than others. For example, I mean, it's strongest in respect of criminal offences, for obvious reasons. If you look at Section 26 of the New Zealand Bill of Rights Act, it specifically provides that no one is liable to conviction or for any act that was not an offence at the time it occurred. Likewise, if a penalty attaching to an offence is increased between the commission of the offence and conviction, the lesser penalty should apply. Similarly, legislation shouldn't deprive individuals of their right to benefit from judgments obtained in proceedings brought under earlier law, or continue proceedings asserting rights and duties under that law. Sometimes, however, retrospective application is required to achieve the policy intent or the purpose of the legislation. One thing I would say, though, if that is the case, it should be justified and clearly stated in the legislation. At times, new law may need to apply, and as such, new law may need to apply retrospectively, for example, to litigants in completed or pending cases. If not doing so would undermine that policy objective. We come across retrospectivity in tax legislation not infrequently. Usually it results in a taxpayer-friendly outcome, clarifying, for example, the original policy intent. There might be a technical glitch there that needs fixing. Just one practical observation I've had over a number of years is that select committees always have a really keen eye on anything retrospective. So for even if that's for good reasons, they always have a close eye and ask that question. So some practical advice I'd have is make sure you have all your justifications fully explored and lined up. Not only when you're introducing the legislation, but also when you're preparing for select committee, because that will be an area of focus for sure. It can, in terms of looking at whether or not it should apply, range of things you should look at. It's often useful also to consult with Crown Law if that's applicable. But before consulting with them or anyone else, you should first consider some of the main scenarios where retrospectivity might be appropriate. And again, in the tax context, there's a few of these that we regularly follow. So you might want to look at is it in the public interest? Is it entirely intended to benefit those that are affected? Look at it if it validates matters that are generally understood and intended to be lawful, but are in fact unlawful due to a technical error, for example. Look at if it addresses a matter that is essential for public safety, that might be another matter, or if it provides certainty as a result of litigation. Lastly, and a really important one, if it decriminalizes conduct, a really important example where this was clearly appropriate was if you look at Section 7 of the Homosexual Law Reform, for example, that was one where retrospectivity was clearly appropriate.
That's a really important list, isn't it, Graham? And it sort of, I think what you're saying, and particularly in the tax context, but I suspect it applies more broadly, is if there's upside from that retrospectivity, that's probably okay. If there's downside, there probably isn't. And they're really, really useful insights. So it sounds like the overall question to be considered in deciding how legislation should deal with existing rights and duties is a question of fairness in terms of the rule of law. And if you've got an expedited legislative process, including the absence of any consultation process, that may well go directly to this question of fairness. And it's certainly one of the things that LDAC's focused on is just the speed with which some legislation is being done. That means that some of the considerations that both Graham and Sam have talked about can't be followed through. Savings and transitional provisions require comprehensive consideration for that reason and adequate time to develop. It may require consultation with both LDAC and PCO. And some of that's not about requirements. Some of that's about actually getting someone else to test out the judgments that are being made in terms of the advice to ministers and to select committees. And while there's a presumption against retrospective application of the law, it's not black and white. It's not a black and white rule in the way that both Sam and Graham have talked about. There are scenarios where explicitly including retrospective application is necessary to support the purpose of the legislation. If so, this should be done in consultation with Crown Law. Now, just another quick reminder, we have 4 questions in the Q&A already. If you have a question from that section we've just dealt with or the chapter we've just dealt with, please pop that in the Q&A button or use the Q&A button at the bottom of the screen and we'll do our best to answer those questions. So we're now going to move on to interpretation and application of new legislation. And I want to turn to Sam. What should officials be aware of when considering legislative interpretation?
Yes, thanks, Guy. The starting point is that legislative interpretation is the role of the courts. And there's a whole set of rules that derive from both common law and Part 2 of the Legislation Act 2019 that help us to understand how courts will go about that job. So it's important that we're familiar with Part 2 of the Legislation Act. This contains some principles of interpretation that we'll discuss today. It has default definitions, rules that apply to commencement, amendment and repeal, rules around the exercise of powers, and even rules that apply to how time and distance is measured in legislation. So it's important that we know how these default provisions apply, so that we know whether they're appropriate for our circumstances or whether we need to either override them or restrict or extend them in some way. In terms of legislative interpretation, the starting point really is Section 10 of the Legislation Act, which says that we get the meaning of legislation from its text and in light of its purpose and context. So the starting point then is the words themselves, and sometimes that's called the literal rule. We look at the natural and ordinary meaning of words. This is where the default definitions of the Legislation Act can come into play, because those are the definitions that apply unless you define them separately in your legislation. So it's perfectly normal to define them differently if you need to. And I think there's an example of this that we'll all be familiar with, is in the Official Information Act, working day is defined differently from the default provision. But you need to know what they are and understand whether or not they will work for your circumstances. as Section 10 says, it's in light of purpose and context. So we come to the purpose of the legislation, what the legislative scheme is trying to achieve, and clearly an important part of that is the purpose clause itself. And again, on the LDAC website, there's some really helpful supplementary material on how to design a purpose clause, and it's worth looking at that to assist you in your thinking. The broader context that can apply includes as the legislative intention of the scheme overall, the particular provision and where it's located in the Act, features in the Act such as headings and diagrams and other explanatory material can be used to provide that context and understand how the provisions will be interpreted. And there's also extraneous material can be considered, including Hansard and Select Committee reports, which many years ago was courts were prevented from considering parliamentary material, but that's now reasonably commonplace that that's an aid to interpretation. Some of the other things to take into account are Section 6 of NZ Bora, which provides that if the courts can interpret provisions consistently with the rights and freedoms in Bora, then they should do so. Equally, TTIP and international obligations might require the courts to lean towards a particular interpretation. So those are some, again, extraneous to the particular legislation, but they'll have an impact on interpretation. One of the final things to think about, I think, is Section 11 of the Legislation Act says that legislation applies to circumstances as they arise, which is a pointer to the need to try and future-proof legislation and to be able to anticipate what might arise in the future to ensure that your legislation is robust and has longevity. So these are all things that we'd need to consider when designing the legislation in order to ensure that the court's interpretation supports the outcomes that we're trying to achieve.
That's really good. And hopefully people in our audience today and arguably others who watch this later on get the point that actually there's a range of guidance that helps that and some considerations that help that interpretation and understanding where the courts might go. So that's one part of the puzzle. The second part of the puzzle is, well, how do you apply this legislation? Now that's obviously pretty broad, Graham, but do you want to just share your thoughts in terms of how legislation should be applied?
Yeah, well, that is pretty broad, to be fair. I'm not sure we have the time, or if I have the individual know-how to do that justice. So, I mean, I'll start by defaulting to the LDAC guidelines. Are a good place to start, and that will often be my default answer. That said, I mean, we'll go over a couple of the basic rules of application that do apply to all legislation in the time we've got. Yeah, firstly, it's probably important to consider and provide for when legislation commences. That's a common issue. As Sam said previously, if you don't provide for this explicitly, the legislation will come into force the day after it receives royal assent. Often there are separate dates that you want to apply, but if you don't provide for that, it's the day after royal assent. Yeah, while that might seem like a minor detail, law coming into force at the wrong time can result in an array of unintended consequences. So that's one pitfall to be aware of. Basic principles of commencement clauses are that they should provide certainty about when legislation is in force, and also provide, I mean, one of the key things here is to provide adequate public notice of the commencement of legislation so people are aware of their rights and obligations, and so that they can undertake any preparatory action that they need to in advance. As I said before, LDAC has there's the guidelines. There's also some supplementary material available that's specifically relating to commencement clauses. That's on the website, and I think that's well worth a read. You should also have regard to all the rules that apply to the amendment and repeal of legislation, I'd suggest. Not considering them, again, can have unintended implications. Just one example here, you should be aware of the rule that references to old legislation may also be a reference to new legislation. Yeah, Chapter 13's got a much more comprehensive and probably comprehensible analysis of this and some other related issues. Sam mentioned time and distance, and it kind of on first glance is a bit of an odd one, but that can certainly be relevant when designing legislation. I think from experience, it's sometimes easy to assume an obvious outcome might apply, but various interpretations taken on that could have implications. That can easily, you can see that playing out when it comes to things like court deadlines, sentencing, leases, licensing, reporting deadlines, for example, filing dates, and so on. And it can get pretty complicated pretty quickly. I guess I think this is another example where you should clearly think about what it is that you want to achieve. Be very clear in your mind about that. Have a check with the LDAC guidelines and materials. Familiarize yourself with the Legislation Act 2019, and from personal experience, speak to your friendly PCO drafters after providing them, as I said, clear drafting instructions. Personally, I've found that to be really helpful at getting exactly the right outcome that you want and not falling into any of the pitfalls. If there's one practical advice, just keep that front of mind, and look, your drafters might well speak to you about that, but good to raise it just to make sure you're getting the right outcomes in.
I think there's a bit of a theme developing in our webinar today, and that is some of the stuff that looks relatively straightforward on the surface clearly is not. There is some guidance and so on that helps us through all of that, but certainly worth taking some other advice as you move forward with developing policy and legislation. So just to sum that up, interpretation and application of the law create the basis of how the law has effect. There's more complexity behind how these elements work than it might seem on the face of it, the point I've just made, and officials should familiarise themselves with the relevant rules relating to interpretation and application that come from the common law and Part 2 of the Legislation Act. LDAC guidelines also provide guidance around how to approach these elements when designing legislation. So that's the end.